Good morning, Your Honors. My name is David Rodstein, and I have the privilege of representing Turok Capital, the plaintiff in the case below. I'd like to reserve 5 minutes for my rebuttal. May it please the court. This case is about fairness. Fairness requires that the field of play not change in the middle of the game, especially if only one side is able to anticipate that change is coming. That's exactly what happened at the trial of this case. Turok Capital Partners arrived at trial ready to try the issues framed by the pleadings, all of the pleadings. When Turok alleged filed its initial complaint, it put 3 issues into play: the existence of a commercial note, a commercial mortgage, and a commercial guarantee. Whether those commercial agreements had been breached and the amount of damages flowing from the breach. Those were fair game for either side to present evidence on.
But you framed it originally as just a breach without taking into account the subsequent modifications.
In both complaints, Your Honor, the plaintiff did not take into account the extension agreements, which there's some dispute over whether that qualifies legally as a modification. But the reason that Turok did not allege those subsequent agreements is because Turok's right to recovery was not based on those documents, nor was the amount of damages it was seeking. Counsel for the plaintiff.
Wasn't the defendant's expectation going into trial that which was framed by the pleadings? And the pleadings seemed to be based on a set of documents that were initially executed, not any subsequent extension agreements or modifications. And that was your opponent's whole beef at trial, was they weren't agreeable. The fact that the extension documents or modifications had been produced in discovery, they didn't think that was enough. It wasn't framed by the pleadings, and the trial judge agreed with that. I don't see anything in the pleadings other than the founder's defenses that, which I think they carry a burden on, that raises the issue on their side.
Well, our argument, Your Honor, is that the pleadings frame the issues for everybody. That once the extension agreements are raised by the defense, that's fair game for both sides to present evidence on. And what's really striking about all the cases cited on this issue, Kuhlman, Nolan, Blodell, Tracy, Morales, MTGLQ versus Leones, and Hammock, is in none of those cases did the defendant raise, or did any party raise the modification agreements? And so when the modification agreements have not been pled, period, by anybody, then the court has to entertain an objection. Hey, this is outside the pleadings, because it honestly is.
I'm not really helping you out, because I've read your reason. I'm hearing what you're saying. I'm still not understanding what the legal purpose of this surprise notion is. The extension, modification, whatever you want to call it, those were played by the defendants, right? They're fair game. They apparently talked about it, they argued about. Ultimately, you get a ruling. Let's assume for a moment that the trial court got it wrong about Nolan, Nowlan, however you want to say it, Blodell, and this notion that you have to, the plaintiff, once a modification agreement comes up, has to, for whatever reason, go back and modify or amend their complaint to match the pleading that's now in play. Assume that. What do you do with paragraph 10 of the final judgment that says plaintiff did not prove at the time plaintiff filed this case that the defendants were in default for the promissory notes and mortgage? Why is that a basis to affirm by itself?
Because it was a clearly erroneous factual determination.
So we're in this respect, we're no longer arguing an issue of law. We're arguing the evidence didn't support it. It was not competent substantial evidence.
Correct.
Okay.
And that's based on, if I may, that when the case was filed in January of 2022, according to everyone's arguments and evidence, the operative extension agreement was the 3rd extension agreement, which called for a maturity payment, the entire amount due, on October 1, 2021. That date came and went, requiring some 6-figure payment, which was never made. So when the case was filed, there was indisputably a default. The complaint alleged a default of a specific date in 2021 and all subsequent payments, including that default payment that was not made. So there really was no evidence on which to find absence of a default in this case. On the pleading issue, because I see it's important to the, it's of concern to the court, I think it's important to first of all, emphasize that again, the issue only comes up and only has to be dealt with by the court as to whether a party should be allowed to amend to conform their pleadings to the evidence or should be precluded if that issue has not been pled by anybody. This notion that the defendant can raise issues and the plaintiff is not allowed to present evidence on those issues, which is
Well, I mean, is there any requirement that that happens, like in any other context? A defendant raises an affirmative defense and now it becomes incumbent upon the plaintiff to amend their pleadings to conform. Is there any law, is there any case that ever held that, any context that ever has held true?
No, the plaintiff is not required to re-plead what the defendant has already pled.
Right.
And so at that time, once that issue was a fair game issue for both sides, it was an error.
It's fair game for the defendant who makes that part of its case in chief, raising a defense. You're still stuck with the pleading as drafted. When you're, I guess, second amended complaint.
To the extent that my client was stuck, they were stuck with the pleadings as drafted. I don't know of any case that says that the plaintiff may only present evidence on its claims and not on the defenses. I mean, an analogy might be in a traffic accident case, a defensive failure to wear the seatbelt. And the plaintiff certainly isn't precluded from asking his client, his counsel from asking his client, wearing the seatbelt. It's an issue for the trial. And that really is the part of what's going on in this case and the incorrect application of Nolan and the other cases. This notion that issues can be only one side is allowed to present evidence on issues that have been pled. That's essentially like saying that there's a goal on the field that one side can score on, but the other side cannot defend, and that's just not fair. And the Supreme Court spoke to this issue essentially of fairness in Cabot. Just 2 years after the civil rules had been adopted by the court, about the pleadings are about notice and making sure everyone knows what's going to be tried. And that's really the issue here. Turok knew that the extension agreements were going to be tried. So it came ready with its evidence to try that issue. To then be told at trial, no, sorry, you can't defend that goal. It has no precedent in Florida law. And this court also said in Tracy, regarding the prejudice analysis that's required by Rule 1.190, when Turok's counsel had been prevented from introducing its version of the extension agreements, which was important because it was different from the defendant's version, and was told you can't introduce that evidence because it's outside the pleadings, outside the pleadings, not your pleadings, the pleadings. That was right away a false premise because it was squarely within the defendant's affirmative defense. But the court also went on to say, I would exercise my discretion to never allow amendment of the pleadings in the middle of a case. And in Tracy, this court said, it must be remembered that Rule 1.190b, like all rules of civil procedure, aims, and this is a quote from the Florida Supreme Court, to prevent the use of surprise, trickery, bluff, and legal gymnastics. That the court went on to say that prejudice turns on the litigant's right to notice of what to prepare for at trial. And if that right has been infringed, that creates prejudice. The defendants didn't have their right to notice that the extension agreements were an issue for trial infringed. They pled the extension agreements. When you say, hey, this is an issue, you can't then say at trial, oh, you can't tell the court about that issue because I didn't know you were coming with it. That's the real essence of the core of what's at play in the pleading issue in the case. The trial court's factual.
Let me ask you a question. Wasn't it part of the plaintiff's burden to prove a default under the operative documents?
Yes.
And the default was a failure to pay time, right?
Correct, especially the
And the documents that are pled in your pleading, in your complaint, don't make any mention, and you never tried to amend until you got to trial to conform to the evidence. To set up the
I'm sorry,
docket,
didn't
you never tried to amend the complaint after you filed the, I think it was.
There was a First Amendment
The
complaint.
First Amendment complaint. And during that time, payments were made and documents were signed. So the defendant gets to trial, and the pleading that you're traveling on for your case in chief alleges breaches of the note and mortgage and guarantee that were in place originally. The defendant then says, you lack standing to pursue this because I'm not in default on the basis of documents that you have that didn't plead. How is the defendant on notice of what you are seeking relief for?
Well, first of all, there's a premise in the question that there were payments made between I think the original complaint and the amended complaint. Unless I misunderstood, that there were no payments in the record during that time, which is actually an important fact regarding the purported fourth extension agreement. But as to the rest of the question.
Well, wait, payments made, you and I are not talking about the same thing. Wasn't your client applying reserve funds during that time? Do I have that wrong?
No, the interest reserve funds were exhausted in the first year of the loan. But like the originally expected term of the loan had interest reserves in an escrow account that were all paid out to pay those 12 payments. After that, the defendants were making those payments on their own. The part of I think I'm starting to forget it, but the part of the question about how is it that the defendants were on notice? Well, they were on notice that the extension agreements themselves were going to be discussed in court. That was not a surprise. In fact, they admit that in their answer brief. We were not surprised by the extension agreements. And what's important is what's the effect of those agreements? The effect of those agreements was only to extend the final maturity date when all the money had to be repaid. And at the time the case was filed, standing is certainly not a question. Default is not a question because, again, the third extension agreement was the one in effect then. The fourth extension agreement hadn't even been printed by that time when the initial complaint was filed. And under the third extension agreement, the maturity payment was required on October 1, 2021. There was no payment on October 1, 2021. And the only payment, that would have been a six-figure payment of some amount. The only payment in the record made after that date is $6,200 made in November.
Wait, so you filed the amended complaint in the
amended complaint was
summer of 2022?
May 17th, 2022.
Okay, and at that point, all the extension agreements were in place and you say that the defendant hadn't paid pursuant to them.
Well, three extension agreements were in place.
So why didn't you include those in the complaint?
Because Turok that wasn't the basis of Turok's right to relief. Turok's right to relief was based on the original commercial loan documents that said you're borrowing $352,568 and you're going to pay it back.
And am I correct that by not pleading the extension agreements, you were basically foregoing whatever, I think there was like a fee or a payment of some kind
Correct.
associated with those. And you were taking a decision, we'll forego that, we'll just make this clean and quick, we just want the original note.
That's exactly right. And in fact, when that issue came up at trial and there was a colloquy between the court and plaintiff's counsel said, look, Your Honor, if the extension agreements are a problem for that reason, we're not seeking them. My argument is that once the defendants pled them, they have to live with that pleading for good or for bad and on remand, because we are asking this court to reverse and remand with instructions to enter a judgment for Turok. That the amount
that you made instruction.
We would ask that the court remand for the trial court.
Because let me specifically address the concern that I have once we sell. If we were to buy everything that you're selling today, if we were to go along with your argument, wouldn't the property demand basically be open up the proceedings again and let you put on the evidence you were putting on about the effects, scope, what have you, about the extension agreements, or fully consider both sides' presentation of what effect, if any, the extension agreements would have, et cetera, and it plays out however it plays out. how do you get the win? Given that what your complaint was they raised this issue and we were precluded from presenting evidence on it.
Well, I think the first part of my answer to that, and I see I'm already into my rebuttal time, but the first part of my answer to that is, it's important that this court really focus on the fourth extension agreement and make a determination on that. Because if the fourth extension agreement did not come into existence, which again, it could not have, because by its own terms, it required two things that didn't happen, a signature and a fee. Then this court can simply remand for determine the amount of damages. That's the only further proceedings that are necessary. Because default is proven on the cold record, because the amount of the principal amount of the loan being $352,568 is clear on 8 signed documents signed by the defendants. And in the settlement statement that dollar for dollar accounts for that entire amount. If this court tells the trial court that was the amount lent, there was a default on the maturity date before the case was filed, and there was no fourth extension agreement, now figure out how much is due, then that would be the extent of the further evidentiary proceedings.
Counsel, excuse me,
Yes, sir.
as you noted, you're into your rebuttal time, but use your time as you wish.
I'll stop here, just ask the court to reverse and remand with those instructions. Thank you for this.
Thank you very much. Who's up? Mr. Jaffer and Mr. Williams?
Steele Williams, sure. May it please the court, Steele Williams and John Jaffrey here for the Appalese Capital Servicing and Tracy Williams. To start the analysis, I think at trial, and every proceeding, certainly in civil court, is the pleading frame issues. What has the plaintiff pled in their case in chief? In this case, it would be, what is the agreement? What are the documents that constitute the agreement? What's the breach of those documents, if there's more than one? And then what are the damages? That would be what the pleading requirements are for a plaintiff. A defendant has a similar burden under the basic rule that the pleadings frame issues for due process reasons, for notice reasons, for fairness reasons. So trials are not surprises of things. Okay, so the defendant has to plead what their answer is based on what has been pled and assert defenses, affirmative defenses to what has been pled. That is the basic rule. Here we have a plaintiff that gets to trial and in a very short summary tells the court and opposing counsel, me, we're going to present a bunch of evidence. There's a promissory note. There's a bunch of other documents that constitute the agreement of the parties. And at the end of the day, we're going to amend to conform the pleadings to the evidence. That can't possibly be the standard by which civil proceedings will work from a due process standpoint.
What if, and I'm just going to throw this
Sure,
out
sir.
there, everybody involved just had a fundamental misunderstanding about the necessity to amend this complaint? Why couldn't it have been the case, as it is so often in so many commercial disputes, the plaintiff had master of his complaint, they had one view of what the operative documents were. Defendant says, no, there's some other documents that are at issue. You both pled them. The court hears evidence from both sides about all of those issues, and then reaches the conclusions that it reaches about all of the documents that both sides have put into play by virtue of their pleadings. For whatever reason, that didn't seem to happen here. Help me out, like, why did that happen?
Well, a plaintiff is required to say, this is what we're asserting is the agreement. This is the promissory, which they did, the promissory note. And then there were further agreements of the parties that extended and changed the basic underlying, which I pled. Yes, sir.
You got in evidence.
Which I pled that there was 4. And the other side is asserting there was only 3.
Fine, the issue is raised, it's broached by both sides.
Well,
let it play out. Why were they prohibited, why are they precluded from presenting evidence on an issue you pled and raised?
Because it goes to notice and fairness as to whether it would have affected my client's proof.
But you knew that was an issue because you pled it. That's what I'm struggling with.
Well, I don't think it's fair for a plaintiff to rely in their case in chief what the defendants has raised as affirmative defenses.
Why? That happens in every trial. A competent plaintiff's attorney has to address preemptively the issues that are raised by the other side. Every trial I ever did, that was one of the first things you did. You raise your theory of the case, you lay out the theme, and if the other side has some important issues that they're raising their defense, you darn well better address that on the front end. Why are there any title issues you raised?
Because they have the initial burden to prove what the agreement is and the substantive breach of that agreement.
And they made their best case, which was, hey, we think it's a promissory note, we won't want to recover our promissory note to get these extensions, we don't want to recover the fees that were associated with them. You all convinced the trial court, no, there were extension agreements, fine, but that still has to play out, right? I mean, there's still an effect about whether or not you're in breach of the extension agreements.
But they have not pled just the promissory note. They have pled that there's a breach of the promissory note in May of 21, which was way outside of the terms of the promissory note that was attached to the complaint upon which they're traveling on.
I think
So
really
from
what your argument here is that it was never raised below, which is that they were under an obligation to file a reply to your affirmative defense, that even assuming that the extension agreements are correct or operative, the defendant is in breach of them. I think that's what the argument would play out in terms of the plea, that you all never raised that.
that was not raised at the trial level, and there certainly wasn't a reply filed by the plaintiffs.
It wasn't, and you didn't argue that below, you didn't argue it here.
Right. We're just proceeding, as I was initially stating, that the pleadings frame the issues, and as a defendant, you're not going into trial wondering, well, what is the agreement that we're going to be talking about here based on what the response is going to be to my affirmative defenses.
And I'm not trying to pick on you, but clearly you were, because you raised extension agreements that they hadn't raised. So there's very clearly a dispute. The pleadings make that loud and clear. There's a dispute about the extent of the agreement, whether or not these extension agreements are in play, when the note became due, I mean, it's a balloon note, so that's a pretty big issue, when it's due. So the issue's in play.
The issue's in play, but it certainly affects, from a defendant standpoint, the posture of how they're going to address what is owed, when default interest applies, when, what is the communication between the parties as to each of the extensions that are occurring. At the end of the day, we did put forth the fourth extension, and the evidence on that was significant. There was testimonial evidence that there was ongoing communication between the parties. One, payments were being made. How much interest do we need to continue to make before we get this fourth extension in play? That's why there's payment records of payment of interest only being made after the third extension had lapsed and not been paid. There's also evidence in the record of a payoff being received that was, it was $325, and yet it was claiming a principal balance of $350. And so there was testimonial evidence that there was a problem getting the proper payoff from the lender. That problem and that communication continued, but there is ample evidence in the record, documentary evidence, of communication between the parties and extending the agreement. And that supports the testimony that was in the record that you're making payments, you were trying to get the payoff is wrong, you were told you could just make the interest payments, and you were never told you were in default, and we're going to get this extension in place. And that's what ultimately happened. And then we get, after the fact, well, the extension wasn't signed. Well, no, the extension was drafted, sent to my clients, they signed it, sent it back, and then there was no further communication saying, well, we're not going to accept that as a signed agreement because we didn't sign it.
And we never get the benefit of any findings from the trial court on a lot of those points because it kind of gets cut short based upon its understanding of Nolan. But we do have one finding that I'd like you to address, and in particular what I heard from your friend on the other side, which is the standalone finding of the trial court. There was no default. Y'all were not in default at the time the complaint was filed. Counsel suggests that there's just no common substantial evidence to support that. point me in the record, where do we say with confidence that there is confidence substantial evidence to support that independent?
There's testimonial evidence that the parties had been communicating about what the payoff was, what the payments were required for paying interest only for November and December leading up to the filing of the complaint. What's happening here is the lender's communicating with my client, telling my client, there's no default, just make interest payments only. We will put together the proper payoff that's needed, and there was significant discrepancies in the payoffs in the record. There's ample evidence that there's communication between the parties that there isn't a default occurring. There's documented evidence that my clients made interest payments during that period of time after October, the third extension principal was owed. There's only evidence from my client that there's communication occurring. There's significant evidence that the parties were of the understanding that the matter wasn't in default. That's what they were communicating to my clients. And that's why they were putting together a very extensive, lengthy fourth modification. So just because that agreement gets papered up later on in January after filing occurs, that just means the lender is not communicating with whoever is communicating with my client as to the loan and when it's going to be due and what's considered a default. My client was of the understanding at all points in time, up until the point of her signing the fourth extension, that it wasn't a default, that she had made all the interest payments necessary to keep it out of default, and that's what she was being told. So to then claim in this court, oh, not at the trial level, but here, oh, well, you're in default anyway, and it doesn't matter what we were telling your client.
Doesn't that tie though into the common substantial evidence? Help me out. Isn't that intertwined with the problem or potential problem, at least arguably, that the other side was not allowed to present evidence that they wanted to present on that extension?
On the fourth extension agreement or the third extension agreement?
Either one.
I don't think that they offered any evidence on those issues. I think
on the judge pretty clear that he wouldn't want to consider it. I mean, did they need to do a formal proffer after the judge said, no, please disclose, I don't want to take anything, under no circumstances I want to accept anything?
Well, certainly that was in their case in chief in regards to what they had pled and applying the standard of the prejudice analysis that the other side is going to affect the proof of the other side as to the case in chief. But the plaintiff lender in this case wasn't prohibited during or in response to the defendant's case in chief to bring out whatever they needed. And even after the closes of both.
They can't present their evidence in your case in chief. It's not.
But they can certainly present rebuttal evidence. They certainly can present also, they can present to say that they're not, they know that the affirmative defense has pled modification for modifications. They certainly were aware of that from the pleadings from a fairness due process standpoint to begin with. They certainly could have come to court with all the evidence in the world to defend or to address that during either their case in chief or in my case in chief. That didn't happen. And even still, if they weren't prevented from presenting rebuttal evidence or that's essentially, they were not precluded from addressing the fourth modification. They cross-examined Capital's witness on the fourth modification. They cross-examined on the emails associated with fourth modification. They cross-examined the payment of interest payments only after the payoff was due under the third modification. So there's substantial and there's significant evidence for the trial judge to have found that, wait a second, when you guys are communicating with the borrower, and we're not just talking about a phone call, one phone call, we're talking about significant communication that's documented in emails, that's documented in payment records, that's documented in payoff requests, and there's communication, hey, you sent me a payoff request November of 25 in 2021 that's wrong, because you don't include what you're claiming, it was completely wrong. Okay, and then we have further evidence in the record that another payoff occurred that was $180,000 more than that first payoff a year and a half later. And that, the lender in the trial said, yeah, that was wrong. That was a complete error of payoff. So there's significant evidence in the record that what was actually owed by my clients in November and December and to the point of trial, if we wanted to pay it off, was still in dispute because we couldn't get a proper payoff. That was evidence. It was unrebutted as a matter of at the trial level. I hope I answered the question. But that nonetheless, 4 or 5 minutes.
Yeah.
I don't think the standard is that a plaintiff lender can come to the trial and say, well, we're just going to present all the evidence, and at the end of the day, we're going to conform to the evidence. We're going to amend to
Let me
conform.
make sure I understand in simple terms what
Yes, ma'am.
what I hear you saying is this was a moving target, both with respect to exactly what was in default and when, and the measure of damages associated with that default. And in a perfect world, you would have had a complaint that put you on notice as to what the due date default events were, so that you would be able to defend that claim as opposed to whatever happened to show up. Is that, am I right?
That's a fair assessment. And I think that comes from the basic principle that the pleadings frame the issues, and at a foreclosure lender analysis is, and especially here, this case is the hallmark case for that principle being significant, because we've got a promissory note where the lender says, the promissory note at trial says it is not ambiguous, and it says up to $352,000. Then at trial, the lender says, well, wait a second, that means we lent you the entire money and interest is on the entire amount of 352 from the get-go. And we want to use other documents that are not attached to the complaint that we're going to use as evidence to then form what the party's agreement is to then get to that 352 number. With the sort of the unusual fact that's verified, the amended complaint says that only 250,000 was lent. So at trial, you're going to say all this loan term agreement, this proposal agreement, the promissory note, the mortgage, this group of documents then puts forth this argument from the lender that 352 was one that actually was lent, and we're entitled to default interest on that 352 from May 1st, not October 1st of 2022. The numbers were all over the place. There's ample evidence of that. The trial judge specifically found that the promissory note was not ambiguous, that there's defined terms in the promissory note. It says up to 352. It doesn't say we're loaning you 352,000 and we're charging you interest on that from the time of closing. That's the basis. That's the assessment of the trial judge. From a pleading standpoint, the Nolan case, the Tracy case, in this foreclosure rule, if you will, requires that the lender put forth what the agreement is. And if there's written modifications to the agreement, put those forth, and then they sue on that agreement. They assert what the breach is of that collection of agreements, and then there's a fair assessment of what the damages can be, and the defendant is on notice from a due process and fairness standpoint how to address that at trial. Just to conclude, the lender had specific notice that they needed to include these modifications prior to trial. Okay, they knew it from the day invariably that the answer and affirmative defenses were filed. From a fairness standpoint, it's not proper for the lender to come to the trial and say, we're going to present a bunch of evidence and then we're going to amend at the end of the day. Thank you, Your Honor.
Thank you, Mr. Williams. Rebuttal?
Thank you, Your Honor. First, the amount of the principal that bear interest or interest, $352,568. That wasn't made up. That, although one or two of the documents do say up to, that was the amount lent. It's on the closing statement for the loan, where everybody gets noticed ahead of time. Here's what the loan is for. Every dollar of $352,568 is on the settlement statement. That is plaintiff's exhibit 8, I believe, in the trial. No, 8 was the demand statement. It is in both sides exhibits. That's as to the amount, the principal amount of the loan. As to the amended complaint saying 250, counsel stated that it said only 250,000 was lent. That's not what the amended complaint says. It says the amount currently due and owing is $250,000. The difference is, and this is key to understanding why there's a difference between these numbers, is that $102,000, the difference between 250 and 352, 102,000 is clearly identified on the closing statement, on the term sheet, signed, both of them signed by Ms. Williams, as the construction funds that were lent, that were held in a separate escrow account. Once they're lent, and the lender has parted with those funds, they bear interest. The next item I'll address is that there were communications that said there is no default. That's not in this record. There were communications, there was discussion about another extension, but nobody said there's no default. And even, no matter what those communications were, at best, those are the first element of an estoppel argument. But an estoppel argument also requires, you told me something, and therefore you shouldn't be able to foreclose. I relied on that to my detriment.
I'm not sure it's so cabined as that. I think that plays into the affirmative defense that they do about the existence and the extent of the extension agreements.
Except that the fourth extension agreement, Your Honor, was dated January 27th after the case had been filed. At best, if that extension agreement came into existence, which again, we argue that it did not, because 2 requirements were unmet. If it came into existence, it was a settlement agreement in the middle of, during the pendency of a lawsuit. And during the pendency of a lawsuit, if an agreement is reached, by the way, there's not any evidence in the record of a single payment under that agreement, not a monthly interest payment and not the maturity payment, which under that purported fourth extension agreement was due May 1st, 2022. If you look at from the time the case was filed until May 1st, 2022, the plaintiff didn't do anything. It filed its complaint, making clear.
Maybe you all have a subsequent complaint that comes down, later on to recover, since all extension agreements are presumably exhausted and presumably also. I mean, that plays out how it plays out. But
well, right, and the way it played out is even the defendant didn't act as if that was a valid agreement because she didn't pay anything. They didn't pay anything. The company and the personal guarantor. As to the argument that the breach date in the amended complaint of May 1st, 2021 somehow limits the plaintiff, it does not, because that allegation says, and all subsequent payments. Florida law is replete with cases from all the districts, I believe it's all the districts, certainly this one, saying that an allegation of all subsequent payments means you're on notice that from that date forward, we're saying you defaulted. And even if you come up showing some evidence that that date was not defaulted, you better show that you didn't default on any payments after that date if you're going to get a legitimate ruling that there was no default. There clearly was a default in this case because one of the subsequent payments was that October 1st, 2021 maturity payment that required all the money to be paid back. And the post-maturity payment that counsel referred to was a $6,200 payment. That's not anywhere close to the amount due on maturity. It was her effort to try and show some interest in the fourth extension agreement that had not even been drafted yet. It hadn't been drafted. It hadn't been sent to her. And 2 points finally is that when Turok sent that drafted extension agreement to the defendant, it was a proposal for an offer because by its own terms required that both parties sign and return the document to each other. When Capital Servicing executed that fourth extension, purported fourth extension agreement and sent it back, that was the offer document. Because in order to be accepted, Two Rock had to countersign it. That never happened. So it never became an active agreement. And finally, to the extent that we're talking about the potential affirmance on some issues, which I hope isn't going to happen. The one thing that I said in my initial brief that was so critical is that it's important. The court just think, be aware that if it agrees with me that the fourth extension agreement did not come into existence, but affirms on all other issues, that would cut off Two Rock's right to recover this loan, period. Because there would never be another default that comes due. The court found no default. And if this court says there was no fourth extension agreement, then there are no more payments due. So that's what we would certainly ask on remand, that there not be that combination of findings. Fourth extension agreement not in existence, which we do want found, but affirming on other issues, that would put us in a terrible bind. But thank you.
Thank you, counsel. Counsel, both sides, safe travels back.
Thank you.